Good afternoon. This is a test. Anyone out there hear me?
Yes, I can hear and see you.
Thanks so much. Bye-bye.
Good afternoon. Just doing a quick sound check. Can you hear me?
Yes, we can hear you.
Thanks so much.
Good afternoon. Is Ms. Weisenthal, are you ready?
I'm ready.
Thank you. Good afternoon. We're now on the record. It is 1 p.m. on Tuesday, October 1st, 2024. This is a pre-hearing conference and proceeding number 24A-0296E, Public Service Company of Colorado's Wildfire Mitigation and Public Safety Power Shutoff Plan. I'm Eric Blank, and I'm the chair of the commission. Can my colleagues introduce themselves for the record, starting with Commissioner Plant?
Hi, Commissioner Tom Plant.
Commissioner Gilman.
Good afternoon. This is Commissioner Megan Gilman.
Thank you. Let's keep going with the parties. Public Service Company.
Good afternoon. My name is Tyler Mansholt, Legal Counsel for Public Service. Also with me is Mr. Robert Kennedy, President of Public Service Company.
Thank you. Welcome. Trial staff.
Yes, Chair. This is Assistant Attorney General Ross Smith. I'm joined by my co-counsel, Assistant Attorneys General Josh Horman and Justin Larson. And I believe we also may have a couple of members of trial staff here if needed. So great to see everyone.
Thank you. CEC.
Good afternoon, Mr. Chair, Commissioners. Michelle King of the law firm Holland and Hart. I'm here on behalf of the Colorado Energy Consumers and also would like to enter the appearance of Austin Rushoff and Christine Roach.
Thank you. Climax.
Good afternoon, Mr. Chairman and Commissioners. Richard Delfano for Climax Molybdenum Company.
Welcome, City and County of Denver.
Good afternoon, Mandy MacDonald from the Denver City Attorney's Office. Here on behalf of the City and County of Denver. I also see that Dan Shea and Vince Fujetta from our CASR office are on the call as well.
Welcome, Kosa Sia.
Good afternoon, Mr. Chair, Commissioners. Jake Schlesinger of the law firm Keys and Fox, representing Colorado Solar and Storage Association and the Coalition for Community Solar Access, standing in today for my co-counsel, Ellen Kutzer.
Welcome, Western Resource Advocates.
Good afternoon, Parks Brosa representing Western Resource Advocates.
I think I've run out of names, so if anybody else I failed to mention, Ms. Stockmeyer, EOC.
Good afternoon, Chair and Commissioners. Gabriela Stockmeyer here before you today on behalf of the City of Boulder. We're co-counsel, and Veronique Van Giem, the City Attorney, could not make it today.
But any other appearances?
Yeah, yes, good afternoon. Good afternoon, Chair, Commissioners. Kate Crampton, Assistant Attorney General on behalf of the Utility Consumer Advocate.
Mr. Borgia.
Yes, good afternoon, Mr. Chair and Commissioners. This is Michael Borgia. I have with me my colleague, Mark Chinchero. We are from the law firm Davis, Wright, and Tremaine. We're here representing Comcast.
Welcome.
Thank you.
Any other appearances? Commission Counsel.
Yes, good morning, or good afternoon, Mr. Chairman. Commissioners, Paul Gomez, Attorney General's Office, on behalf of the Commission.
Did I miss anyone? With that, Mr. Gomez, would you like to get us started?
Thank you. Again, good afternoon, Chairman and Commissioners. This pre-hearing conference is convened for the purpose of determining whether extraordinary conditions exist, further extend the deadline for the Commission to issue a final decision in this matter, as provided under 40-6-109.5 subsection 4 CRS. That statutory section provides that the Commission, in particular cases, under extraordinary conditions and after notice in a hearing at which the existence of extraordinary conditions is established, may extend the time limits specified in subsections 1 and 2 of 40-6-109.5 for a period not to exceed an additional 130 days. As we all know, subsections 1 and 2 of 40-6-109.5 provide for a combined time period of 250 days after an application is deemed complete for the Commission to issue a decision as prescribed by Commission rules. This provision is generally captured in Commission rules at Rule 1303 of the Rules of Practice and Procedure. As indicated under 40-6-109.5 subsection 4, notice must be provided, as well as a hearing at which the existence of extraordinary conditions is established by the Commission. The Commission provided the requisite notice by its interim decision number C24-0687-I, page 15, paragraphs 41 through 43, issued on September 23, 2024, subsequent to its discussion at the September 18, 2024 Commissioners' Weekly Meeting. Section 40-6-109.5, subsection 4, does not specifically delineate what circumstances may constitute extraordinary conditions. Rather, it leaves it to the Commission's sound discretion to make that determination. What constitutes extraordinary conditions is determined on a case-by-case basis in the context of the proceeding in which the determination is made. I would note that this is not an evidentiary hearing, but a hearing for the Commission to make a determination whether it believes extraordinary conditions exist here. It should be noted that 46-109.5 also provides that the 250-day time limit specified in subsections 1 and 2 may be waived by the applicant pursuant to subsection 3, and if so waived, the 250-day time limit is not binding on the Commission. However, Public Service has previously represented and again states in a filing that it made yesterday its notice of party conferral positions on Public Service Company of Colorado procedural schedule options, or shortened to notice, which will be discussed in more detail in a minute, that its proposals are intended in that notice are intended to follow the guidance made by the Commission in decision number C24-0687-I, even though the company does not support an extension of this proceeding beyond the schedule included in its procedural schedule motion filed on August 29th, 2024. So I'll get to now the extraordinary conditions that exist here. As was set out in decision number C24-0687-I, compared to the 2020 Wildfire Mitigation Plan, the company's 2025 through 2027 plan has doubled the geographic areas of focus, quadrupled the proposed budget for capital investments, expanded the categories of work and types of mitigation activities, and proposed hiring new staff and incorporating new internal business units. For some activities, which were once pilots, such as the enhanced power line safety settings, Public Service proposes to roll them out on a large scale. Moreover, Public Service seeks to fund this work through a new concurrent cost recovery mechanism. The application currently before the Commission involves extraordinary levels of complexity. The company's cost recovery proposals have implications for other pending and anticipated applications, as well as raising questions about how federal, state, local, and ratepayer funding can be interwoven and leveraged to reduce wildfire risk overall. In addition, the company's application functionally includes two ensconced but distinct efforts: the 2025 through 2027 Wildfire Mitigation Plan and the Public Safety Power Shutoff Plan. The two plans will invoke different questions about the roles of local, state, and federal entities in cost recovery and communications, different approaches to balancing effective regulation with utility managerial discretion, and different measures of successful implementation. Public Service's request for approval of a PSPS plan may create unanticipated new risks as the Commission moves forward. The Commission has to be careful and deliberate in its consideration of utility proposals, so its decisions do not result in standards that may be challenging to implement and may not serve changing customer needs. Colorado has experienced several devastating wildfires in the last few years, resulting in significant loss of life and extraordinary property loss. In addition, Public Service conducted a PSPS in April 2024, which through the miscellaneous docket that the Commission opened to investigate that, was found to be lacking in communication and coordination. Consequently, a fulsome record is imperative upon which the Commission can make well-reasoned and well-informed decisions. The participation of entities with unique subject matter expertise, such as federal and state agencies, local offices of emergency management, local first responders, local business leaders, and residential customers, is imperative, as their input will provide the basis for a determination of what Public Service proposes in its Wildfire Mitigation Plan and PSPS is necessary, sound, and dovetails into the needs of those parties as seamlessly as possible. Commission, you have committed to developing the most complete record possible for this proceeding and to enhancing your understanding of the real-world implications of the proposals put before you through gathered information, public comments, and testimony. Based on this, you have set several goals you aim to utilize to help guide proactive engagement by parties and other stakeholders in what is clearly a highly complex proceeding. Those goals include: 1, to better understand the interrelationships of federal, state, and local agencies and private or nonprofit sector partners in wildfire mitigation. 2, to better understand the interrelationships of federal, state, and local agencies in emergency management preparedness and response. To understand how Public Service can best leverage existing resources and how the Commission can efficiently support appropriate collaboration and coordination. 3, to understand whether and how Public Service can leverage funding resources and opportunities available across federal, state, and local levels. And 4, to understand whether and how the company is leveraging existing situational awareness tools, including risk tools, maps, cameras, and where permitted to make such additional investments, so it is able to provide system-wide benefits through resource sharing. Based on those priorities that you emphasized in decision number C24-0687-I, 3 circumstances emerge as reasons for finding extraordinary conditions exist in this proceeding. First, the complexity of the Wildfire Mitigation Plan and the PSPS proceedings, standing alone, are daunting. However, combined into a single proceeding, as Public Service has done here, the scope of the proceeding is truly expansive. Second, the size of the wildfire mitigation investments and the complexity of the unique cost recovery mechanisms proposed by the company will require expending considerable time and resources to completely analyze. Third, and most importantly, the need for additional process, which will include an informational session within the adjudicatory process by which the Commission can place into the record critical information and evidence from representatives of appropriate federal and state agencies, local offices of emergency management, first responders, local business leaders, and residential customers, especially those customers dependent on durable medical equipment. This information is critical for the Commission to understand the efficacy of what Public Service proposes in context with the needs of those outside parties. This issue alone would be sufficient to find that extraordinary conditions exist here in order to extend the statutory deadline an additional 130 days. However, all of these issues taken together clearly demonstrate the complexity of this proceeding and the need to issue a decision that allows for appropriate investment in wildfire mitigation plan and the development of a PSPS that protects the lives and property of the residents of Colorado. On September 30th, 2024, Mr. Robert Kennedy, president of Xcel Energy Colorado, filed a letter with the Commission. Mr. Kennedy expresses his concerns regarding finding extraordinary circumstances here. He maintains any delays could hinder effective and timely execution of the. And he contends timely approval of the wildfire mitigation plan is essential since wildfire risks are increasing and timely action is required to mitigate those risks. He additionally states that any delay in the schedule will disrupt any coordination with federal, state, and local agencies by continuing uncertainty of the company's proposal. He also claims that delaying the schedule will create uncertainties in resource planning and allocation, leading to increased costs and reduced effectiveness. Finally, Mr. Kennedy alleges that a delay in approving the wildfire mitigation plan will signal a lack of urgency or concern from the Commission to rating agencies and investors. Also yesterday, Public Service, as I mentioned earlier, filed a notice of party conferral positions on Public Service Company of Colorado's procedural schedule options. Public Service's additional filing states that it proposes actually 3 options to a finding of extraordinary circumstances. The first proposal includes an evidentiary hearing, which we'll refer to as the April option. It schedules a proposed evidentiary hearing for April 2025. The second option, which we'll refer to as the May proposal, proposes an evidentiary hearing for May 2025, while a third option proposes the Commission bifurcate the Wildfire Mitigation Plan and the PSPS, so companies' investments, budgets, and cost recovery proposals are heard and decided within the original statutory deadline, while subsequent litigation would address the PSPS and related communication and engagement efforts. Public Service also notes in this filing that with regard and points to the large amount of discovery it would be required to respond to if the Commission decides to extend the deadline for these 2 proceedings or this proceeding, and so proposes that the Commission places limits on discovery. It therefore requests a pause in discovery propounded on it until late November. Its April 2025 hearing option would extend the time to file answer testimony 2 months, extend the time to file rebuttal cross-answer testimony an additional month, and a hearing date an additional 2 months. Its May 2025 option would extend the time to file answer testimony 3 months, extend the time to file rebuttal cross-answer testimony 3 months, and extend a hearing date 3 months. Their bifurcation proposal would conduct a hearing on investments, budgets, and cost recovery associated issues with answer testimony due November 22nd, rebuttal cross-answer testimony due January 10th, 2025, and a 5-day hearing beginning February 3rd, 2025. A proceeding on the PSPS and communication engagement issues would have answer testimony due May 13th, 2025, rebuttal cross-answer testimony due June 17th, 2025, and a 4-day hearing beginning August 5th, 2025. I believe that sets out all of the filings made by Public Service. Unless you have any questions or comments at this time, I'm ready to make a recommendation.
Yeah, if you can make a recommendation, that'd be great.
I recommend that you find that extraordinary conditions exist here pursuant to 40-6-109.5 subsection 4 that require you to extend the deadline to issue a decision in this proceeding an additional 130 days, or to August 28th, 2025. It may be that you will not need the entire 130 days and a decision can be issued sooner. I would note that the proposals put forth by Public Service in its filing made yesterday, while extending the time on those proceedings would, in essence, only result in a savings of about 30 days from the Commission finding extraordinary circumstances and extending the proceeding an additional 130 days. So that's my recommendation. And before you deliberate and take a vote, you may wish to hear from Public Service and the other interveners.
I guess Commissioner Plant, Commissioner Goman, do you have any questions, or should we ask the company to respond, hear from the other parties, and then ask our questions? Commissioner Plant?
I don't have any questions at this time.
Commissioner Goman?
Same, nothing to ask right now. Thanks.
All right. Mr. Mansholt, would you like to respond to Mr. Gomez or Mr. Kenny?
Thank you. Thank you, commissioners. The company very much appreciates your attention to this proceeding, which is very much important to Public Service. And we also understand that our notice was just filed yesterday, laying some out these items and thoughts. as well as Mr. Kinney's letter. So thank you so much, and the prompt and diligence in reviewing that material and the great recitation by Mr. Gomez in laying that out. We still do have some concerns on a full 130-day extension, and we still are advocating for potentially a more creative bifurcated approach to this proceeding. But before we get to maybe all those procedural issues, I would give Mr. Kinney an opportunity if he has additional thoughts and concerns about the 130-day extension to offer those now, if you'd like.
Mr. Kenny?
Thanks, Chairman Blank and Commissioners, and thank you, Mr. Gomez.
Just before, Ms. Crampton, do you have an objection?
Yes, I do object. As Mr. Gomez stated, this is not an evidentiary hearing. Public service is essentially offering a witness to provide testimony or what can be considered sworn testimony without being subject to cross-examination or providing the other parties opportunity to present witnesses. So I would object to public service essentially offering testimony on these issues.
I guess, Mr. Gomez, I would not view this as testimony. I would view this as context that may be useful to setting a procedural schedule. But I think all the parties will have an opportunity to put on witnesses, cross-examine the company's witnesses before any final decision is rendered. So I would overrule that objection, but would like to bounce it off you first.
Yeah, thank you, Mr. Chairman. Ms. Crampton's correct. This is not an evidentiary hearing. This is merely a hearing, undefined hearing under 40-6-109.54 that the commission is required to hold in order to hear from parties as it makes its determination, which is the sole determination of the commission as to whether extraordinary circumstances exist. Certainly, because it's entitled a hearing, you can hear from parties, but would also emphasize that Ms. Crampton is correct that this is not evidence and merely comment from parties prior to you making your determination.
So with that clarification, you'd support overruling the objection and allowing Mr. Kenny to speak?
Yes, I think that'd be fine to let him speak.
Mr. Kenny.
Thanks, Chairman and Commissioner Gilman, Commissioner Plant, and all the parties. Thanks for the opportunity just to provide some additional context. I'm not going to recite what was in the letter, but what I would say is maybe some additional context for the consequence of finding extraordinary circumstance. I think there are four reasons why, four distinct but related reasons why the commission shouldn't find extraordinary circumstances, or if the commission were to find extraordinary circumstances, not to take the full 130 days. And so, again, without reiterating or reciting what I wrote in the letter, first, the need to plan and execute work, particularly that work to be done in the non-winter months. We need some certainty so that we can do that. And the schedule that we proposed in conjunction with the other parties allows that to happen. Second reason would be the need for certainty as at least an important condition precedent to continuing to execute the most efficient coordination with other parties. And this isn't to say that we aren't already coordinating with these other parties, but if the commission were to change direction or change anything in the plan, what we are coordinating with the parties would become uncertain or become irrelevant. And so the need for certainty so that we can continue executing that efficient coordination in the most efficient way possible. The third reason is the need for certainty in order to be able to effectively allocate capital. Again, concern here is with midstream changes into the work plan that the commission might decide by virtue of an extension. And then the last reason that I will reiterate is, there is a need to send a strong message to the external community, particularly the investment community, that the state supports wildfire mitigation efforts by investor-owned utilities. The injection of unnecessary or additional uncertainty serves to send the opposite message. And so those are 4 very quick reasons that I wanted to just reiterate to provide additional context. I'm happy to answer any questions that you might have as well.
Mr. Mansholt, I do have 1 or 2 questions, but Mr. Mansholt, do you have more to add?
No, I think it's probably appropriate, Mr. Chairman, if you'd like to proceed.
I guess just so I understand option 2, in that option, is the company agreeing to waive the April 20th 250-day statutory deadline?
Just so make sure we're talking clearly, you say option 2, are you referring to the April or May hearing date?
The May hearing date.
Yeah, just for a point of clarity, for both the April and May hearing proposals, the company has not agreed to waive its statutory rights for a 250-day hearing, nor does it support a finding of extraordinary circumstances. Instead, what the company was endeavoring to do was understanding that if you overruled our proposals on extraordinary circumstances, we could at least try to facilitate some stakeholder party discussion of what a schedule may look like to try to assist you, even though we ourselves don't support that type of an extension for this proceeding. What I instead would like to offer is that what we most strongly support is more of a bifurcated approach to this proceeding. We believe we've heard some concerns that perhaps this proceeding is too unmanageable with too many issues, most directly related to the PSPS plan, related communication and engagement efforts. And so the company is open to perhaps a 2-phased approach, like we've done in the ERP context, to resolve this proceeding, or perhaps other creative options, like bringing the PSPS plan back into a separate filing. We think there is some creative options out there that are available because of other ongoing commission proceedings, namely the current April 2024 miscellaneous docket on our PSPS plan, which has been discussing our interim proposals for our PSPS, as well as the recently opened investigation into outages, including those related to wildfire settings in the Commission's iDocket. So with those other ongoing dockets, as well as this docket, what we're advocating for most strongly is a way of splitting the issues out in this proceeding into 2 separate buckets, and most namely so that the investments, strategies, and cost recovery can be resolved first and within our current 250-day statutory timeframe deadline. That's a lot of information, so hopefully that was clear, but if not, we're more than glad to clarify that any way we can.
I guess I understand that your preference is to bifurcate, but if the commission wants to keep them together, what we're calling the May hearing option, how does that become workable if the company is not offering to waive the 250-day deadline? Isn't the commission's only choice to go to find extraordinary circumstances?
I think that's perhaps a question best left for Mr. Gomez, but under this circumstance, for clarity, the company is not agreeable to waive its statutory rights. And I can tell you that when we designed that schedule, the amount of time was intended to reference the 2 to 3 months that your previous commission decision referenced is what you were proposing to potentially extend the schedule by. And so the company's positioning of that schedule was intended to be consistent with your 2 or 3 month extension idea in an attempt to assist you in reviewing schedule proposals.
But I'm still confused if the company's not willing to waive the 250-day deadline, which is April 20th, isn't the commission's, I guess for you, Mr. Coleman, isn't our only option to find extraordinary circumstances if we want this more extended schedule like the May hearing option?
Yes, if you look at their May 2025 hearing option, it has a 9-day hearing commencing on Monday, May 5th, and statements of position due Tuesday, June 10th. Under the 250-day statutory deadline, that 250 days runs on April 19th, which is a Sunday, so April 20th, 2025. So if you were to even consider their May 2025 hearing option, you would have to find extraordinary circumstances since the company has represented that it's not willing to waive the 250-day deadline.
Commissioner Plant, any questions for Mr. Mansholt or Mr. Kenny?
I just had one clarifying question for Mr. Gomez, actually, from what he just said. The April option there, Mr. Gomez said, has the hearing April 1st or somewhere around the beginning of April, but statements of position wouldn't be until May 6th. That would still need an extension. Is that correct?
That's correct, Commissioner. Because since the 250-day deadline expires on April 20th, and we would not get statements of position until May 6th, well beyond that deadline. And then there would have to be time for the commission and advisors to analyze all of the evidentiary information received, the testimony, come up with the recommendations, and for you to then deliberate and issue a decision on that. So we would be well past that deadline.
Yeah. Okay. Thank you for that. And Mr. Mansholt, I know this isn't your preferred option, but again, looking at that May option, which is option 2, you move out the answer testimony technical conference out into February. And one of the things that we've discussed is having a SIM, some sort of an opportunity to talk to other state agencies. I mean, as obviously, wildfire mitigation is an important issue for Excel's customers, but it's also something that the state is very interested in pursuing, and for which the state and counties and federal government all adopt a significant role. And so one of the things we've said is that we'd like to hear their input and how such a mitigation plan might intersect or interact or complement, contrast. We don't really know, but with their existing plans and with their existing efforts. And in looking at that option 2, like I said, you begin sort of virtual comments at answer testimony technical conference in February. What we've discussed in the past is having actually that public SIM in February, with those answer testimony technical conference, those things coming in November, December. So basically, rather than holding off for 3 months and then basically starting in February with those first steps, we would do those earlier before the SIM, and then pick up with rebuttal and cross answer testimony after that. Is that an approach that the company has any particular concerns about, or any reason that might the end times? I guess what I'm getting at is the end time of an evidentiary hearing, May 5th. That's pretty consistent. It's just some of that stuff that happens at the front end where the timing is a little bit different.
I think I understand the question. Generally, the April and May hearing options laid out in our notice, for the most part, tried to move the dates back by the 2 or 3 months reflected by where the hearing landed, so that all the dates would be proportional to that similar move. That's where those timelines landed. In terms of the dates you referenced happening in February, the technical conference under the original agreed to schedule was to take place in December. And so with the 2 to 3 month move back, that's why this date got moved to February. The company would heavily request that that technical conference would take place sometime in the first quarter of next year. We can understand it could be, doesn't have to be necessarily on February 10th. I think there's some room for it to be a little bit before that date. But by allowing us to move that technical conference into the first quarter of next year, we'll be better positioned to give quite frankly, a better technical conference, including on our outage map and outage map proposals, which are ongoing work streams within the company, and giving us time available to position those into the first quarter of next year would be beneficial, we think, for all the parties to see actually what we've really been working on. In terms of the other dates in February, whether it's the virtual public comment hearing or answer testimony deadline, the company doesn't have very strong feelings on those dates, but it imagines the other parties probably do.
Gotcha. Okay, thank you very much for that. Appreciate it.
Commissioner Gilman.
I just want to make sure I understand, Mr. Mansholt. So in the original procedural schedule proposed by the company, as I understand it, that technical conference was in like mid-December. So you're saying you would like to delay the technical conference and move it back by at least a month or two to allow you to prepare more? Have I interpreted that properly?
Generally, yes. The original schedule agreed to by all the parties. It wasn't necessarily a company proposal. It was an accommodation that all the parties agreed to at a technical conference that was to take place on December 18th. In the proposals we conferred with on the parties, as we moved all the dates back, we moved it back to February 10th. And we do think that moving it further back to February 10th would be for the benefit of the public interest, to give us more time to make a better prepared technical conference, most especially on our outage map presentation.
Okay, and then I guess we have the other parties here. Maybe they want to respond. Is it necessary to have the answer testimony occur after the technical conference based on what the company plans to present at the technical conference in order for the parties to be properly informed to prepare answer testimony?
I've heard previously in discussions that some parties, or a lot of them, would prefer their answer testimony to be after the technical conference.
Okay.
So that they can incorporate potentially their testimony about things learned at the technical conference.
Okay.
The company doesn't have a strong feeling about that. That's what we understand other party positions to be, though.
Okay, but your position is you would like a 2-month delay from the originally proposed schedule on the technical conference, which may well drive other parties' opinions of other dates within the schedule.
Yes, and as we're moving all the dates back 2 or 3 months, we think the same process makes sense for the technical conference.
Okay. That's it. Thanks.
Thanks. Let me just ask one more question, then I'll open it up for the other parties. Just speaking for myself, because we just got this yesterday. Assume we wanted something, or assume this commission could work with the May hearing dates and end of July decision date, but wanted to move around some of the internal deadlines as Commissioner Plant was asking about. Is there any way we can do that without a finding of get to that outcome without a finding of extraordinary circumstances, given that you're not willing to waive the 250 days?
Not that I'm aware of, Chairman Blank.
Right, you may be making this easy. Any other parties who'd like to weigh in, just hold up your hand or turn on your camera, please. Mr. Smith.
Thank you, Chair. It has not been mentioned yet. I know that the company has requested as part of its proposed schedules I would call it a discovery moratorium until the end of November. And to the extent that the commission would be considering that, I would just note that staff would vehemently oppose any attempt to so limit discovery on the company's direct case. This is as I know we've said multiple times, this is a massive proceeding with many issues at stake. I mean, we're talking about billions of dollars, and the suggestion that this massive direct testimony should be precluded from discovery simply because the company was ordered to file supplement its deficiencies in its direct is just that doesn't make logical sense to me. And I think I speak for my client when I say that would unfairly prejudice nearly every other party except for the company in this proceeding. So I think to the extent that that's being considered, staff would urgently object to that.
Understood. Let's see if we can resolve the extraordinary circumstances and scheduling issues, and then we can focus on the discovery. Ms. Stockmeyer.
Thank you, Chair. Boulder supports a finding of extraordinary circumstances here. As Mr. Gomez has said, the plan represents an unprecedented amount of investment and very complicated issues. And it includes currently a proposal for approval of the the power shutoff plan. Boulder knows firsthand the importance of wildfire mitigation. The community is Public Service Company's highest risk tier for wildfire risk, and the community has faced devastating fires in recent years. At the same time, Boulder knows the unintended consequences that result from use of broad brush mitigation tools, such as the PSPS. Residents and businesses in Boulder represented approximately 70% of the 55,000 customers impacted by the April PSPS event. And Boulder appreciates that the commission acted quickly to convene the miscellaneous docket. The commission has appropriately raised concerns with gaps in the record in this proceeding, requesting supplemental direct, a commissioner's information meeting, and additional public comments. While Boulder agrees that time is of the essence to add wildfire mitigation improvements to its system, Boulder agrees with the commission that the application involves extraordinary levels of complexity, involves extraordinary implications and costs, and deserves a fulsome record, as Mr. Gomez stated. I also just want to note that the company's proposal to bifurcate the PSPS from the non-PSPS issues is unacceptable. Boulder is adamantly opposed to this attempt to separate out PSPS issues from what it terms non-PSPS issues. It's ambiguous. It's unclear how that would happen. It's also would be administratively inefficient, prejudicial to interveners and customers, and fail to create a full record for the commission. Boulder's position is that PSPS is inextricably intertwined with investment, budget, and cost recovery of most of the other parts of the wildfire mitigation plan here, and that the commission needs to be looking holistically at the suite of tools in the mitigation toolbox, and that to do so, you need to consider these all together in one proceeding. With regard to what Mr. Smith just raised, I also want to note that in its pleading, the company noted or suggested that Boulder took no position on the discovery moratorium. We would in fact agree with staff that a discovery moratorium is not appropriate. And lastly, just responding to the potential procedural schedule here, I would just flag that currently in the initial proposed schedule, the answer testimony deadline of November 22nd. I think if the commission were to maintain that at this point, it would be very prejudicial to interveners. We have yet to see supplemental direct testimony from the company, nor I think has that even been fully defined. And so parties have had to pump the brakes a little bit here to see what they were fully responding to in terms of an answer strategy. So I would just request that any schedule not stick to that November answer deadline at this point.
Thank you, Ms. Stockmeyer. Other parties, Commissioner Plant, you have a question for Ms. Stockmeyer?
Yes, I did. Thank you. Just a clarification. So if we had in our original schedule that the answer testimony was coming a ways before the technical conference, and I understand that you'd like to, in light of the rest of the revisions to the schedule, you'd like to move out the answer testimony timeframe as well. But is there any concern if the answer testimony were to continue to come before the technical conference, or do you have an interest in having that after the technical? Is there a timing between those two that's important?
Sure. I think ideally the technical conference would happen before answer testimony. What Boulder did agree to in the initial proposed schedule was that at a minimum, parties need to be able to have an opportunity to provide testimony either with the cross answer deadline or at a minimum live at hearing, although certainly that could be a little unwieldy. So I think preferably answer testimony after the technical conference, but if otherwise, at least having a rebuttal cross answer deadline that can allow parties to include that in their testimonies.
Thank you. Any other parties that would like to comment? All right. I'll ask one more time, Mr. Mansholt. If the commission is struggling to operate within that 250-day deadline, again, do you see any other alternative than a finding of extraordinary circumstances given the company's unwillingness to waive the 250-day deadline? It sounds like you've answered that.
But other than the bifurcated option,
yes.
If we put that aside, then yes, I agree. We're not waiving our statutory rights beyond 250 days for anything beyond the April current statutory deadline requirement.
Okay. Ms. King.
Thank you. If I may respond briefly to the potential for the bifurcated option and just express CEC's opposition to that approach. CEC certainly supports the Commission's finding of extraordinary circumstances and believes there is much that is extraordinary about this situation, both in terms of magnitude, scope, breadth, and depth. The May hearing dates are preferred for CEC, and the bifurcated option is just, I think, in addition to the comments that Ms. Stockmeyer raised, it's administratively inefficient and also troublesome if we use the Clean Energy Plan as a comparison, which I believe Mr. Mansholt raised in his remarks. We are on year 3+ of that plan, and as happens in the sequence of that proceeding, circumstances continue to change, which render decisions that were made previously either obsolete or stale or no longer suitable to what's ahead. And in a matter such as this that requires such extensive coordination within the state overall, not only among the commission, the utility, and the parties to this proceeding, I think having an efficient proceeding that is done in one fell swoop is the most efficient course forward. And so we would strongly oppose any bifurcated approach and encourage that should the commission wish to find extraordinary circumstances, there is much that is extraordinary about these. Thank you.
Thank you, Ms. King. Would anyone else like to speak? I think I'm ready to vote. I understand the pressures the company is under, and I'm sympathetic to it and would commit to get this resolved with a written order as soon as feasible. But given the company's apparent complete unwillingness to waive the 250-day statutory deadline, I am really reluctantly willing to vote to find extraordinary circumstances, which I think this record and fact situation strongly support. It's not my preference about how to proceed, but I don't think we have another option, given my perception that the issues are inherently related, and that bifurcation is not a great way to go. So that's where I'm at, but we got this pleading yesterday. So Commissioner Plant,
Yeah,
where you
I would agree with that. I think it's obviously there were a number of criteria that were laid out by Mr. Gomez that articulates why extraordinary circumstances exist, and I would support that motion.
Commissioner Goman, anywhere you'd like to go? Where are you at?
Yeah, I agree with Mr. Gomez with regard to the finding, as well as the reasoning. Looking at the proposal for the bifurcation, it doesn't seem to me clear that would provide the best review and coordination. And also time-wise, it somewhat deprioritizes the PSPS until after next summer, delaying any real discussion and conclusion on that important component of the plan. I think it's essential that we ensure we have adequate time to consider a proposal that's been vastly expanded from the previous plan of nearly $2 billion. But of course, this doesn't prevent any interim planning or investment by the company based on their obligation to continue to provide safe and reliable service. This is primarily within here a lot of questions about cost recovery and other details of the plan. And it seems somewhat clear to me, the company seems to be asking for a delay in the technical conference, which is a fairly important early step in this adjudication. So somewhat necessarily, it seems as though there's a bit of a delay brewing, no matter what, in that information does not appear it'll be ready by the December 18th date in the originally proposed schedule anyway. So I agree with Mr. Gomez and would find extraordinary circumstances here.
All right. I mean, I'd just say for me personally, I probably could have lived with those May hearing dates and a July written order, but I see that the company has given us no way of getting to that schedule short of an extraordinary circumstances filing. So if it's all right with you two, I do this as an ABC order. Does that work for you two?
Yep.
Commissioner Goman?
Yeah, and then I think would the intent be that we would come back a different date and hammer out the exact schedule?
Or send it to the parties with some guidance. Mr. Gomez, do you have any other guidance or suggestions for us, or what we should be doing now?
Well, you've made the finding of extraordinary conditions, so that's set. So I think that just to make it clear that you are then extending the deadline to issue a decision here by an additional 130 days, which I would also note does not necessarily mean that you're going to utilize all that time, but that's how far you will be extending the deadline. As far as, and well, let me just stop there for now and then come back.
Yeah, I think that's right. And you might put, I'll check with Commissioners Plant and Gilman, but you might put some language in the order saying we'll do our best to get this, that we're sympathetic to the concerns raised by the company, and we'll do our best to get this resolved as quickly as possible, but there's really no alternative given how this is postured. So would you be all right putting that in the order, Commissioner Plant?
Yes.
Commissioner Gilman?
Yes.
Mr. Gomez, anything else for this pre-hearing conference?
That's it for the determination on extraordinary conditions. I would like to just touch base a little bit with you on a procedural schedule, and it may be a good idea to have some information in this decision with regard to coming up with a procedural schedule that accommodates the parties' needs and especially the commission's needs, and it takes into consideration the time that the three of you are going to need to prepare for the hearing, and to have a procedural schedule that provides for the record that you want for making your decisions here. So I think that we probably need to set out some specifics, some mileposts with regard to when you would like to have this back on the agenda. Would you prefer to have this on next week to make a decision on a procedural schedule? And would you want to also hear from the parties as to a procedural schedule that they come up with, which may incorporate some of the options proposed by Public Service here, which was indicated that some of the parties were amenable to some of those proposals there, and come back with that for you so that you can make a decision on the 9th.
Yeah, I think I would put it on the agenda on the 9th. And I know there's been some internal procedural schedules that sort of, at least in terms of the end dates, track the May option put forward by the company. Do you want to put some of that, some of our preferences in this order, or do you want to wait till next week?
Why don't we wait till next week to discuss that? I would just note, though, generally that advisors indicated that those dates from the May option put forth by Public Service Company are available administratively and for them and for you going forward. So I would just like to throw that out there.
All right. And for me, I think we do need to rearrange the internal dates as Commissioner Plant suggested, but those hearing dates, the statement of position, and an end of July decision, which would be a decent amount before the 130 days run, I think may work, at least for me, and maybe the Commissioner Plant.
Yeah, did you mean the end of June decision? Because I think that's what we had in the original plan.
No, I think if it's early May hearings, I think we're looking at an end of July decision. I think in the company's option, it was an early June statement of position.
Yeah, I think
they had proposed in the May option 9-day hearing commencing on Monday, May 5th, and statements of position due on Tuesday, June 10th.
And then we would probably need 4 or 5 weeks to deliberate and get out a written decision. And I would suspect that would be a multi-step deliberation.
Okay. I was just looking at the table that we got on the existing time schedule. It has the statements of position. They suggest June 10th. We had June 6th, and then we had deliberations and written decision in June. But maybe that has to happen in July. I don't know.
Yeah, wow, that seems too quick to me. But I guess we don't have to decide that now. So
Yeah.
so you'll get out an ABC decision based on this deliberation and decision, Mr. Gomez, and we'll bring it back next week with some further guidance.
Yeah, yeah, that would be fine. And I would just also probably lastly mention that as far as a procedural schedule goes, we would, look for something from the parties, but not include a specific date for a commission decision.
So you would solicit guidance before the meeting next week?
Well, let's just see what the parties propose as far as a procedural schedule, and then internally, I think we can come up with a date for when it would be feasible for the commission to get a decision out.
So I'm now confused. Are we asking in the ABC decision coming out of this meeting for the parties to give us guidance, or do you want to schedule something? Yes.
Yes.
And do you have a deadline for when you'd like to see that guidance?
We'd like to see that so that we can discuss it at next week's weekly meeting, which is the 9th. So if we could get that by the end of this week, that would be great.
All right, so close of business on Friday.
Yeah,
I guess
the 4th.
Before we adjourn, can I just ask you, Mr. Davis, if you have any guidance, suggestions, anything that you've heard that's off or you'd like to direct us?
Thank you, commissioners, Chair Blank. I'm Ron Davis of the Commission's advisory staff. The one thing that I heard today that was not contemplated, I think, before hearing the parties' positions today was that there was a potential benefit of delaying the technical conference. That the company thought that it was necessary to do that. Well, it really wasn't revealed until yesterday. And the other thing that was new is that the intervening parties now see merit in having answer testimony follow that. So those are significant changes in the landscape here that I think the commissioners had not anticipated. The notion of the technical conference was raised in an earlier commission decision from August. So learning about that on September 30th is kind of disappointing. But that's a complication that I appreciate the time to the 9th to work through with the commissioners.
All right, so Mr. Davis will add language in the order flagging that issue maybe. And I guess we're really requesting guidance or elaboration by Friday the 5th.
Yes, I think that would be helpful. It just is surprising to hear from the company that the delay is, troubling, but on the other hand, to take advantage of this opportunity with the commissioners to seek a delay. And that makes your job a lot harder. So that's all I'd like to observe.
And just while we're here, Commissioner Plant, you okay if we add some language along the lines Mr. Davis suggested, requesting elaboration on the timing of the technical conference and the answer testimony to the ABC order?
Yeah, I'm fine with that. I had one other request, and I don't know that this goes in the ABC order, if it's just our indication here in this proceeding. One of the things that wasn't presented to us was the time for having a sim with the other agencies and allowing rebuttal and cross-answer testimony to incorporate any comments that they hear within that sim into their filing. And the timing, it seems to, if you look at the May schedule, it kind of lines up with the exception of those first few things that the company put in February. But if you look at the April timeframe for those initial components, that the company proposed. The technical conference on the 14th of January, public comment hearing on the 16th of January, and answer testimony on the 21st of January. That would leave us, a period in February or March to be able to do that sim, and then have the rebuttal and cross answer testimony, maybe pick up the May schedule after that. So it's just something that I would ask as the parties are considering a potential procedural schedule, to please consider that we would like to have that time period to be able to get the input from the other agencies.
Yeah, I'd like to put that in the order. Would that be all right with you, Commissioner Gilman?
Yeah, that's fine. And with regard to Mr. Davis's point, I certainly agree with adding that. That's the point I was making earlier, the really new news yesterday/today, that the company would actually benefit in preparation from a delay in the technical conference, which I think necessarily drives a lot of this schedule, given the foundational nature of some of the information that may be provided there. So I think recognition of that is important.
Thank you. Mr. Gomez, well, let me ask this, Mr. Manchel, any final issues before we adjourn?
I understand that this hearing is not to be about all the issues for the procedural schedule, and that you're asking us to provide additional commentary by this Friday on some of the issues you've raised. So rather than potentially have a long discourse on those issues here, I think we're happy to file our pleading by this Friday and address them in that pleading to try to make this as efficient as possible.
Thank you. Mr. Gomez, anything else before we adjourn?
No, I think that covers it, and we will get an ABC decision out.
Thanks all. With that, we're adjourned.